An OUI defense case in Maine is really two cases happening at the same time. There is the Bureau of Motor Vehicles process, and then there's the criminal process, which starts at your arraignment. The Bureau of Motor Vehicles part of this case begins when the client receives a notice of suspension. That notice will indicate that on a certain date, they're going to lose their license. Now, this happens before you even go to court. So it's very important to contact me not only when you get that letter, but before the letter, because we need to prepare to fight that administrative suspension from the beginning. That suspension will be fought at what's called a Bureau of Motor Vehicles hearing. This is a little mini trial that happens at the Bureau of Motor Vehicles office. And the arresting officer has to appear, and we have a chance to cross-examine that officer on all of the relevant issues in the case. Many times, these hearings come down to technical issues with the Intoxilizer 8000 and cross-examination of the officer's procedure and protocol in administering that test, as well as his procedure and protocol in giving the standardized field sobriety test. So your lawyer has to know these details of the defense inside and out. I've been to the same training as the cops on field sobriety testing and the Intoxilizer operation. So I know what to ask. I know how to win these motor vehicle hearings. The criminal part of your OUI case will begin at your arraignment. I suppose actually it began at the time you were arrested. But as far as the process in the judicial system is concerned, the arraignment is the first step. If I'm your lawyer, you won't have to go to that arraignment. I'll enter a not guilty plea on your behalf. The next part of the case is called a dispositional conference. We will both be in court together. Prior to that date, which is about 2 months after the arraignment, we would have had a chance to go thoroughly over the discovery, review the videos, go through the administrative process that I spoke about earlier, and we're going to know exactly what our strategy is to get the best result out of this OUI charge. The dispositional conference is my chance to speak to the DA about your specific case in an official setting. There's no trial or hearing that day, but these dispositional conference dates are very important. If the DA and I and you do not come to an agreement as to what should happen in your case, then I will go back into chambers and speak to the judge. The judge will have an opportunity to ask the lawyers, the prosecutor and myself, questions about the case and give his or her input. Oftentimes, there are constitutional issues that arise in OUI cases. These issues are resolved at hearings called motion to suppress evidence hearings. That would be the next step in your case. And oftentimes, these hearings are outcome determinative. If we win the motion hearing, we win the case. And I've had a great deal of success in winning these motions in courts throughout Maine in front of judges who I've been dealing with for, well, over a quarter of a century. If the motion to suppress hearing is not resolved in our favor, then the case moves on to the possibility of a jury trial. Now, jury trials are the crown jewel of the criminal defense system. I've had an opportunity to try many cases in courts throughout Maine, from York County to Portland, Rockland, Belfast, Augusta, Bangor. For the client to go through a jury trial is a very stressful experience, and I realize this. So believe me, you will be very well prepared as to exactly what is going to happen during the trial. You're going to feel confident, you're going to feel comfortable. What I've learned in over 25 years of defending criminal matters, especially OUI, is that the best thing you can do right now is take action. Give me a call. Let's talk about the details of your case. Let's start putting the defense together now. I'm not going to charge you for initial consultation. And I guarantee that at the end of that conversation, you're going to feel better about where you are and what your chances are in successfully defending this case.